Excuse me, the mayor is in the process of logging in.
Okay, thanks.
Mhm.
Hey, Vicky, Ashley from our office is also expecting to join. Is she in the waiting room?
Nope, I have nobody in the waiting room. I need to, I need to resend the mayor a link. So
Okay.
um, I don't see her.
Okay, I'll see what's going on.
My sincerest apologies for being late.
No problem. Let me get the recording going here. Okay.
Vicky, do you, if I share my screen, will I be able to show the PowerPoint, or do you want to do that, or how are we going to do this?
No, you can share the screen and do the PowerPoint. We'll go ahead and let the mayor open the meeting and do the black sheet.
Great.
Excellent. Yeah, I was going to ask if we needed to do that. So let's go ahead and open the meeting. And I'm going to go on mute, but let's go ahead and say the pledge, and I'll come right back off mute when I'm done saying it. So go ahead.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. I heard Vicky conclude it, so I'm assuming we're all probably done with it at that point in time. With that, I would like to go ahead and move on, hand the floor over to Emily, who will be taking us through today's training.
Thank you, Mayor. I do want to, before I start, I'm Emily Mattisar, City Attorney for Hubbard. I want to introduce my colleague who is with us today. This is Ashley Dugill. She joined our office a few months ago. She's an attorney, and she's done some work for Hubbard, and she came to us from Vestas, but she also has some experience in municipal law as well. And she's going to be just observing this training today, but I wanted to introduce her anyway. So that's Ashley.
Hi, everybody. Thanks for having me. I'm just going to be muted in the background, but I'll be here.
Okay.
You're welcome.
So because we do have another Ashley, her email address doesn't follow our standard formula, and I believe it's just her last name, Dugill, Dougill. So then Ashley, the other Ashley who you've worked with in the past, is also here, ashleyD@govlaw.com. Okay, anyways, now I will move forward to trying to show.
I'm sorry, Emily, you spelled her last name really quick. Can you spell
I'm sorry.
it for me?
Yes, it's Dougill.
Thank you.
Yeah. Okay, I am going to see if I can do this here. Oh no, I don't know if I can do a full slideshow. Hold on just a minute. Okay, what do you see my slideshow? Yes. I assume you can see this Hubbard City Council training. Okay, great.
Yes.
I don't think I can do, actually, maybe I can do a full slideshow situation. You probably see my my speaker view, but that's okay. Okay, so today we're doing our city council training. I anticipate it should go about an hour. Vicki has reserved extra time. If you have questions, just feel free to jump in. I don't need to save them till the end. Just interrupt me and I'll do my best to answer your questions. For the goal for today is not that you become an expert on all these issues. Rather, it's that you kind of become familiar enough with the issues that when they arise as you are acting in your role as on the city council, you recognize those issues and then you can come and ask for assistance. So like I said, you don't need to be an expert. That's literally my job. You just need to kind of recognize when the issues arise and come to me with your questions. So the discussion topics today are sort of an overview of the council, which includes the council's authority, the council meetings, and then the types of decisions that you make on the council. Then we're going to do sort of a legal training on public meetings, public records, and then government ethics laws. And those will be pretty brief. I'll try to provide examples when possible. Okay, so the city council's function within the city is twofold. First, to enact city code, aka laws, through the passage of ordinances. And second, to help build a common vision for Hubbard through creative and representative municipal policymaking. So those are just sort of all the other actions the city council takes. And then, of course, in your role, you also help connect the community to the city government and integrate the community's voices. So the city charter, the City of Hubbard City Charter, creates a council form of government, also known as the council mayor form of government. And what that means is that all powers are reserved to the council as a body unless delegated to another person or body. And that is in contrast to a council manager form of government, where a lot of administrative authority is passed to a city manager. As you know, you don't have a city manager. So you as the council retain significant administrative authority, including supervision of staff. Staff are led by 4 department heads: the city recorder, director of administration, the public works superintendent, the finance director, and the chief of police. But I say finance director, as you are hopefully aware, in 2021, council amended the city code to add a city administrator position to serve as the administrative head of the city and generally supervise the department heads. That city administrator position is combined with the finance director, but recruitment for the position is ongoing. I'm sure Vicki has given you more recent updates than I have on that. And also, I want to just note that if you do get a city administrator into office and you decide you want to transition to a council manager form of government with the city manager having more administrative authority rather than the council, and that would include supervision and hiring and firing authority of department heads, then if you decide you want to do that, you have to amend the charter, which requires a vote of the general population in Hubbard. But that is something you can do. I have my paper notes also. So council business, sort of more of the overview. The council conducts its business only as a body. Individual councilors and the mayor, so members of the council, have no independent authority to act on behalf of the city. Only the council can act as a body. And the way council acts is through ordinances, and that's how they pass legislative decisions, resolutions, and those are administrative decisions, and orders, which are quasi-judicial decisions. And when I say quasi-judicial, I mean mostly land use. I tried to look in your code to see whether there were other quasi-judicial decisions. I couldn't really find any, which is not to say I very briefly searched. There could be other non-land use permit decisions, stuff like that, that would be quasi-judicial in nature, but mostly we mean land use when we say quasi-judicial. So generally, council uses Robert's Rules of Order. There are council rules in the Hubbard Municipal Code at 2.10. So the mayor or the council president in the mayor's absence serve as the presiding officer. And if both are absent, then council elects a temporary presiding officer. The council president by charter is elected at the first meeting of the odd numbered year. Also, I wanted to note that. Unless a member, so now sort of general rules of the council meetings, unless a member of the council states that he or she is not voting, his or her silence is recorded as an affirmative vote. So keep that in mind. The city recorder sets the agenda. There is a period on the agenda where council members may bring forth issues or questions not on the agenda, and that may be limited at the presiding officer's discretion. Unless there's a compelling reason, and that's decided by a unanimous vote of the council, then those matters that were not on the agenda but brought up during the meeting shall not be voted on until a later meeting. And that's for basically notice reasons. Next, councilors are expected to conduct themselves with civility and decorum, even in difficult situations and when having, robust discussions about and possibly disagreements about issues before them. And that is in, again, the council rules in the Municipal Code 2.10. There's a section on order and decorum, 210.030, and that discusses disruptions, distractions, other actions, and sort of prohibited actions. Councilors should wait to be recognized by the presiding officer before speaking, and councilors are not to publicly criticize or attack one another, city staff, or other persons. So we're going to talk a little bit about what not to do. This next series of slides is essentially what not to do. So counselors are not to get involved in the administrative functions of the city. So don't attempt to influence city staff on making appointments, awarding contracts, selecting consultants, processing applications, unless it's part of your role, or granting licenses and permits. And to the extent, this is what I was just saying, to the extent that requires council involvement, they will be brought to council as a body for discussion at a council meeting. Also, so still in what not to do, do not attend meetings with city staff unless requested to do so. Questions of staff or requests for additional information should be directed to department heads. And when in doubt, ask the city recorder for direction. Materials that are made available to one counselor in response to a request will be made available to all members of the council so that everyone has the same information when making decisions. Sorry. So more what not to do here. Do not solicit political support from staff. We have circulated in the past political activities memo, so it explains, you know, what public officials and elected officials can and cannot do in political activities. And one of the things you cannot do is solicit political support from staff. I'm happy to circulate that memo again, if you'd like. You should also limit requests for staff support. Routine secretarial support is provided, including mail that received to City Hall is opened unless other arrangements are made. You should check with city staff before responding to correspondence in case they've already responded. And then copies should be provided to the city recorder. It feels funny saying the city recorder and not just saying Vicky, but Vicky may not be there forever. So I'll keep saying the city recorder. That's what's in my presentation. More what not to do. Do not contact members of city boards and commissions to lobby on behalf of private interests. Council as a body appoints members to boards and commissions, but members of the boards and commissions do not report to individual council members. If you observe any inappropriate behavior by a board or commission member, then you should bring it to the mayor, who will provide counseling to that board or commission member. So if you make statements relating to public issues or policies, then you should take care to state whether those comments are your personal opinion or are representations of the official city position. And that also becomes particularly important in political activities and is addressed in that memo I was talking about earlier. It's not really relevant right now because we're not in an election cycle, but you should take care when particularly stating positions on political activities, whether it's a statement from your personal position or the city's. In addition, you should keep all materials that are provided to you on confidential matters confidential, keep them confidential, and you should not mention them to anyone other than your fellow counselors and necessary city staff and people in my office. Okay, we're going to talk a little bit about quasi-judicial decisions. And like I said before, these are mostly land use decisions. So a quasi-judicial decision typically applies pre-existing criteria to an individual person or piece of land. It's not necessarily one individual person, but it's I'll explain it later, a little bit later. It's just a narrow situation. Very few people, not broad. So determining whether a proceeding is quasi-judicial turns on the following factors. First, the decision is bound to result in a decision. Second, it is bound to apply pre-existing criteria to concrete facts. And third, it's directed at a closely circumscribed factual situation or a relatively small number of persons. And that's in contrast to, for example, a legislative decision made by an ordinance. So if you look at these factors, when you're passing an ordinance, the first one, you can choose to adopt the ordinance or not. So it's not bound to result in a decision, such as, for instance, in a land use decision, it's a decision on granting of a permit, for example, where you have to either grant or deny the permit. You can adopt an ordinance or not act at all. Second, in contrast to a legislative decision where there aren't pre-existing or concrete facts, right? You're making and oftentimes in a legislative decision, deciding whether to pass an ordinance, you're creating the criteria or creating the law as it applies. And then lastly, an ordinance is not usually directed at a closely circumscribed factual situation or relatively small number of persons. It applies broadly to everyone the same. Of course, it's certain people may not be, it may not be applicable to certain people, but everyone in that situation, it applies the same to. So that's sort of the compare and contrast a quasi-judicial decision versus a legislative decision. So the reason this is important is because a quasi-judicial decision must comply with general standards of due process. And what that means is typically it includes notice and an opportunity to be heard, an opportunity to present and rebut evidence, an impartial decision maker, a record, and written findings, and those written findings must be adequate to permit judicial review. If the applicant, for example, in a land use hearing appeals, then your written findings must be adequate to permit further review of your decision. Okay, so I already talked a little bit about this. Legislative decisions typically involve more generally applicable policies and standards, and they apply to a variety of factual situations and a broad class of people. Because a legislative decision is the expression of local government policy, you're not required to reach a decision on the legislative proposal, and you can table the issue or decline to review it altogether. And as I said earlier, their legislative decisions are made by ordinance. Okay, another reason it's important to understand the difference is because in quasi-judicial proceedings, ex parte contacts, conflicts of interest, and biases are all relevant issues that must be considered. Whereas in legislative decisions, only conflict of interest issues must be considered. And ex parte contacts and biases are not relevant. They're relevant, but not important to dispose of, I suppose. And I'll discuss that in a minute. Excuse me, I need to drink. Maybe I'll pause now and ask if there are any questions before I keep going. Okay. Okay, so what are ex parte contacts? So I think people generally understand ex parte contacts to mean a meeting, a written communication, a telephone conversation, or just an in-person conversation between a member of the hearing body, so the decision maker, and an interested party that occurs outside of the public hearing process. But they're actually broader than that, and it encompasses any evidence that relates to a pending application and is relied on by a hearing body member, a decision maker, in making their final decision, but that is not fully disclosed. So when you think of it more broadly like that, it may include things such as newspaper articles, blog posts, radio reports, and etc. So an ex parte contact does not render a decision unlawful as long as there is a full disclosure. This is sort of the important thing to remember about ex parte contacts. And so that disclosure must occur at the earliest possible time in the decision-making process. And in order to fully disclose an ex parte contact, there are two components. First, you must place the substance of the written or oral ex parte contact on the record, and you must publicly announce the ex parte contact. And that is in order to provide the public an opportunity to rebut the substance of the ex parte contact. And that's also why disclosure must occur at the earliest possible time, so that the public has an opportunity to essentially address the ex parte contact. And there are exceptions. So under ORS 227-180 sub 4, which relates to permit applications, and ORS 215-422 sub 4, which is planning and zoning, then certain communications with staff are not considered ex parte contacts, but staff may not serve as a conduit for obtaining information that is outside of the public process. And if that is, then it becomes a ex parte contact and must be disclosed. So that's sort of the portion on the council overview. Obviously, the rest of the public meetings, public records, and government ethics are relevant to your role on council, but they are sort of more legal overviews. Again, I'm not going to stop for questions, but if you have a question, you can just feel free to interrupt me. So public meetings. Oregon's form of government requires an informed public aware of the deliberations and decisions of governing bodies. And that means that deliberations and decisions of a governing body must be done in public. So generally speaking, you should be aware of electronic meetings, and that includes emails and social media, as well as serial meetings. Purely social gatherings are not covered as long as you do not discuss city business at social gatherings. What that means is that if you do discuss city business at social gatherings, you risk running afoul of the public meetings law. So just be cautious about that. In your council meetings, the presiding officer has inherent authority to keep order and impose reasonable restrictions necessary for the efficient and orderly conduct of a meeting. And council should not eject an individual from a meeting unless that individual actually disrupts the meeting such that council cannot conduct its business. And generally speaking, the council should first warn the person that they will be ejected if they continue to disrupt the meeting and prevent council from doing its business. And then if the disruption continues after the warning, you can eject the individual. You must, if there are multiple disruptions during the council meeting, then you must apply that law, that rule evenly. So you can't eject one person because you don't like what they're saying and leave another person who was being equally disruptive because they're being supportive of the city's decisions. You have to apply that ejection law equally. And if you do end up in a situation where there are multiple disruptions from the audience, my recommendation generally is to just stop the meeting and resume at a later date. So, executive sessions. Council may use executive sessions to discuss specific matters, and those specific matters are designated by law privately, so not in a public meeting. No final decisions may be made in an executive session, which means that if you are making a decision on something that's discussed during an executive session, you must reconvene an open session and then make the vote in open session. And you don't need to describe exactly what it is, just enough to record the vote. In order to convene an executive session, you must follow specific procedures, which are also designated by law. Vicky's pretty good about having a script in order to convene, and the mayor also very experienced in convening executive sessions. Media is permitted to attend most executive sessions, but may not report on the substance of the conversation in the executive session. However, they can use information that they gather in the executive session to follow other leads. So just be aware of that. Okay, public records. So the public records law governs both inspection as well as preservation or retention of records. The law applies to all government records of any kind. That includes memos, contracts, text messages, notes, photographs, etc. The definition is a writing that relates to the conduct of the public's business. Writing is defined extremely broadly and includes photographs, maps, other things that you may not think of as a writing. When a public records request is made, the city may charge reasonable fees for inspection, but if they do charge fees, then you must adopt a fee schedule. Just because a record is requested, it doesn't mean that it'll absolutely go out. There are many exemptions that exist that permit the city to keep certain documents confidential, though most of the exemptions are conditional, and the record will be produced if the public interest in disclosure outweighs the interest in the exemption, essentially. So the other aspect of the public records law is the retention. The city must follow the retention policy adopted by the Secretary of State Archives Division. Generally, you must keep one official copy of each record for that retention period, which varies depending on the type of record that it is and the information that it records. That duty extends to elected officials and not just employees. So if you have a writing that contains information about the conduct of the public's business, you have a duty to retain that record. And that means that includes social media posts, emails to a home computer or a personal email account, and text messages. And like I said, the definition there is what sort of guides. It's not the format or the location of the record, it's the substance of it. So whether it contains information about the conduct of the public's business. And this is also important because destruction of a public record is a criminal offense. So any tampering with or destruction of a public record outside of the retention policy is a misdemeanor. Okay, I'm just breezing through this since we don't have any questions, but I'll keep going. So now we'll talk about ethics laws, a conflict of interest. So an actual conflict of interest. Oh, before I start on this, Vicky circulated some additional supplemental materials, one on public records and meetings, one on land use decision-making, and one on Oregon government ethics. And the ethics one has really good examples of these situations arising that are taken from actual Oregon Government Ethics Commission opinions. So I recommend that you review that and look at those examples because they are, I think, extremely helpful. So conflicts of interest. An actual conflict of interest is defined under ORS 244020 as any decision or act by a public official that would result in a private pecuniary benefit or detriment. So that means financial gain or loss, not only to you as the individual public official, but also to your relatives and to any business with which you or your relative is associated. We're going to talk a little bit more about those definitions here. So a relative includes the spouse, parent, step-parent, child, sibling, step-sibling, son-in-law, and daughter-in-law of the public official of you. Also, a relative includes the parent, step-parent, child, sibling, son-in-law, and daughter-in-law of the spouse of the public official. So if you have a spouse, that includes your spouse's parent, step-parent, child, sibling, etc. It also includes any individual that the public official has any legal obligation to support, if that's not included in the previous definitions, as well as any individual to whom or from whom the official provides or receives benefits from employment. Again, if any of the previous definitions don't already encompass that person. Businesses with which a public official is associated. So remember, this is important because an actual conflict of interest extends to financial gain or loss to any business with which you are associated or your relative. So a person is associated with a private business if the person is a director, officer, owner, or employee or agent of the business, or if the person here, the public official or their relative, owns or has owned more than $1,000 worth of stock, equity interest, stock options, or debt interest of the private business in the preceding calendar year. So likewise, for publicly held corporations, a person is associated with a publicly held corporation if the person is an officer or director of the publicly traded company, or if the person owns or has owned more than $100,000 worth of stock in the preceding calendar year. Then a person is associated with a business also if they are required to file an annual statement of economic interest and the business is a source of income that produces 10% or more of the person's total annual household income. I think we talk about statements of economic interest later, but that is relevant here as well. Okay, in the case of an actual conflict of interest, a public official must do both of these things. First, announce the actual conflict of interest, and second, refrain from taking official action or participating in any discussion or deliberation on the matter that involves the conflict of interest. So those are the two ways or the two actions you need to take in order to dispose of a conflict of interest. Now, we're going to talk about potential conflicts of interest because those are slightly different. A potential conflict of interest is distinguished from an actual conflict of interest in that the benefit or detriment could occur. So speculatively could occur. Whereas in an actual conflict of interest, the benefit or detriment would occur. So that's the difference. It's more speculative in a potential conflict of interest, but it's still a conflict of interest. So in the case of a potential conflict of interest, the official must announce the conflict, but you may take action on the issue. You may discuss, deliberate, and even vote on a potential conflict of interest as long as you've announced it. And that differs from the actual conflict of interest. Okay. We're going to talk a little bit about the class exception to the conflict of interest law. So where a public official or their relative is part of a class that consists of a larger group of people affected by a decision, then no conflict exists. This is a pretty complicated area of the law because the only sort of decision makers on whether the class exemption applies is the Oregon Government Ethics Commission. So nevertheless, I'm going to try and explain it. The probably most straightforward example I have is, let's say that you are on the council and you have a spouse who works for the city. and your spouse is in a union, right? And you're voting on ratifying the collective bargaining agreement for that union. That's your job as a commissioner or as a counselor, sorry. And that technically could result or would result if, let's say, you're approving a COLA increase as part of the collective bargaining agreement, and your spouse will receive that COLA increase. That could be a situation where let me read, I just want to read the exact language of conflict of interest. Your decision would result in a private pecuniary benefit or detriment to your spouse. So that's an actual conflict of interest. It's probably okay because it's covered by this class exception. Having said that, there's no hard and fast rule on the size or type of class. Like I said, it depends on the facts of each case, and the Oregon Government Ethics Commission is basically the final determination, has the final determination on whether it applies. And I do want to just note here that you benefit from reaching out to the Oregon Government Ethics Commission on questions such as that, because there are protections in the government ethics laws, which if you rely on Oregon Government Ethics Commission advice, then you're protected from liability for following through on that action. So you should not feel hesitant to reach out to the Oregon Government Ethics Commission if you do, worry that a situation has arisen where, there's an ethical law at play. Okay, we're going to talk a little bit about bias. A biased decision maker substantially impairs a party's ability to receive a full and fair hearing. This is relevant to the quasi-judicial decisions that we talked about before, specifically, most commonly, I should say, land use decisions. Bias can be in favor of or against the party or the applicant. Generalized expressions of opinion are not bias. So what is bias? Bias means prejudice or prejudgment of the parties or the case to such a degree that the decision maker is incapable of being persuaded by the facts to vote another way. It can include a personal bias, personal prejudice, or an interest in the outcome. So local quasi-judicial decision makers, who frequently are also elected officials, are not expected to be free of any bias. Oftentimes, that's why you were elected, because you generally favor or oppose certain types of development or decisions. You are, however, expected to set aside your bias when deciding individual permit applications, and secondly, to engage in the necessary fact-finding and attempt to interpret and apply the law to the facts as you find them, so that the ultimate decision is a reflection of the facts and the law rather than any positive or negative bias you may bring to the process. So hopefully that makes sense. Also, as I said earlier, bias is not relevant to legislative decisions. That's oftentimes why you were elected, was to, make those decisions by passing ordinances and etc. Your promises on the campaign trail, but it is relevant for quasi-judicial decisions, which are most commonly land use. Okay, we're going to talk a little bit about gifts and the gifts law. Maybe I'll pause there just to check if people have questions and also drink some water. Any questions? No. Okay, so now we'll talk about gifts. So this is also in ORS 244 the sort of chapter on government ethics in Oregon. The law prohibits public officials, relatives of public officials, and members of the public official's household from soliciting or receiving any gifts over $50 in a calendar year from any source that has or could reasonably be expected to have a legislative or administrative interest in the public official's decisions or votes. So that's kind of a lot of information. Let's break it down a little bit. You are prohibited from soliciting or receiving any gift over $50, and that's in a calendar year. So it can be accumulation of smaller gifts. So where I think this comes most often into where public officials come into problems are buying a drink. If someone buys you a drink, someone with a legislative or administrative interest in your decisions or votes, one drink, that's not close to $50. I mean, it feels like it's getting closer to $50, but the prohibition applies to any gift, accumulation of gifts over $50 in a calendar year. So pretty quickly, one drink is not going to be over $50, most likely. I don't know. That would be a pretty interesting drink. But then only a few drinks reaches that $50 limit. And so that's when you get into trouble. And so this last line, always look to the source of the gift. That means the gift prohibition applies to anyone who has a legislative or administrative interest in the public official's decision or votes. That's the source of the gift. And if that person, if the person who's providing the gift has a legislative or administrative interest, then just be aware and be cautious. However, there are a lot of exceptions. So a gift is anything of economic value. It's not just money. It could be money, but it also could be in kind, anything else that has economic value. But the definition of gift excludes things such as gifts from relatives or members of the household of the public official. So your relatives can give you gifts. Gifts in the form of tokens, plaques, trophies, mementos with a resale value less than $25. It also excludes gifts received as part of your private business, employment, or volunteerism. That's like a watch for retirement, or for example, you volunteered the most hours of anyone at the organization, so you got some sort of gift. That's exempt. It says several other exemptions from the definition of gifts. There's a lot of exceptions. So if something comes up, you can feel free to come to me, go to the Government Ethics Commission to find out if an exemption applies, because there's a good chance that it does. I feel like that's one of the areas where the exceptions kind of swallow up the rule, but you should still be aware. So now we're going to talk about abuse of office. And what that means is that public officials may not use or attempt to use their position to obtain a financial gain or avoid a financial detriment that would not otherwise be available but for the holding of the official position. And there's an example. This one comes straight out of the supplemental materials, but it was so good that I'm going to say it now. There was a situation where some sort of city employee, I think it was a fleet employee, was buying some cars for the city's fleet. And they decided to just throw in an extra car for their own personal use. They were getting this huge discount because they were buying a bunch of cars, and they paid for their own personal car. It's not like they were using city money to buy their personal car. They were just using the city's discount to get the personal car. No cost to the city, but that still violated the abuse of office because they were using their position to obtain a financial gain that would not otherwise be available to them, but for their official position. And so that was a violation of the law. Confidential information. A public official may not further or attempt to further personal gain. This is actually a law in the Oregon ethics laws. So they may not further or attempt to further personal gain through use of confidential information that was gained in the course of or by reason of their official position or activity in any way. So an example would be if you learned about some future development in the city and then bought property for yourself based on the confidential information you received about that future development. You would be furthering or attempting to further your personal gain through the use of confidential information that you gained by nature of your position as a city council member. And that would be illegal. Okay, I mentioned the SEI filing earlier, so now we're going to talk about it very briefly. The annual verified statement of economic interest must be filed by April 15th of each year, and it does become a public record. And it's essentially a form that's provided by the Oregon Government Ethics Commission, and you just fill it out. And it covers your assets from the previous calendar year. And it's best characterized as a declaration of income, holdings, and business associations. It just sort of says, you know, how do you make your money? What's your business association? What holdings do you have? And also your spouse, if you have a spouse. We're going to talk briefly also about nepotism. This is my last substantive slide. So a public official may not participate in the appointment, employment, promotion, discharge, firing, or demoting of a relative or member of the public official's household. Public officials may also not directly supervise a relative or member of the household unless local policy expressly permits it. So that the definitions of relative and member of the household are the same in the nepotism law as in, I believe, the conflict of interest law. And so you may not participate in essentially the employment decisions regarding your relative or member of your household. And we breezed through that. That's all I have. As I said, this training is sort of to help you spot issues as they arise in your role, and then to feel free to get in touch with me when they do arise, or you know, if you think of something tomorrow that you wish you'd asked, feel free to reach out to me. Here's my contact information. Vicki has it also. And I'll stop now and just ask one more time if there's any questions or comments or anything. I don't know how to stop. Okay, I'll stop sharing. There we go.
Emily, this is Mayor Rosticel. Just want to say great job overviewing the material. I think this is my 4th time going through the class, so I don't have any questions by now, but no, you did a great job.
Good, thanks, Mayor.
This is Counselor Steininger. I appreciate all the information, and I think you did a great job of explaining it. So thank you.
Good. Yes. Nice to meet you.
As Emily mentioned, be sure those new handouts, I'm going to provide you with copies at the meeting if you haven't already downloaded them, but to place in your council notebook, which Joseph, you haven't received yet. I'm still updating your book. But there's like she said, there is a lot of good information in those handouts.
So my takeaway on that one, Vicki, that means Joseph shall have the latest version. So if we don't make printouts and add it to ours, we'll always just refer back to Counselor Steininger on all of the updated material. Just a joke, just a joke.
All right. Well, thank you for organizing this, Vicki.
Oh, you bet.
And it's good to touch base with you guys, and thanks for your attention. And I mean, I feel like we're done. Yeah.
Okay, I have no further questions and I appreciate you doing this training, Emily. So anybody else that doesn't have anything, we could get a motion to adjourn.
Excellent. Then I will take it over from here. I will go ahead and make an motion for adjournment.
I'll second that.
There you go, James. Okay, we have a motion and a second. All those in favor say aye. Aye.
I see everybody later.
All right.
All
Have a
right.
good day, everybody. Thank you.
Bye.